Mike Pence will not invoke the 25th Amendment, then the House of Representatives will initiate impeachment proceedings. So in putting these lectures together, I was going to address the amendments, starting with the First Amendment. As you can see, Lecture 1, the right to free expression. However, contemporary events compel me to begin with the 25th Amendment, because that is what is foremost in people's minds. So that's what we will do. We will begin with the 25th Amendment. It was ratified in 1967, and officially it is known as the Presidential Succession and Disability Amendment. A little background to this amendment. When President Kennedy was assassinated in 1963, it brought up long-standing questions about presidential succession. When a president dies, does the vice president automatically become president, or does he only serve as acting president? What happens when the vice presidency becomes vacant? Who determined when the president was disabled and incapable of carrying out official duties? So these are all questions that led to the passage of the 25th Amendment. Now, throughout American history, the vice presidency has been vacated 17 times before the 25th Amendment was ratified. Although no president has ever died in office without a vice president, Congress became concerned when Lyndon Johnson took over after the assassination. He became president and we had no vice president. And Johnson had already suffered 2 heart attacks. And so there was concern about who should take over if Johnson were to have died in office when there was no vice president. The amendment was implemented for the first time in 1973, when then Vice President Spiro Agnew resigned and President Nixon nominated Gerald Ford as Agnew's replacement. But then in August of 1974, as many of you remember, Nixon resigned the presidency, and so Ford became president, and Ford nominated Nelson Rockefeller as vice president. And so for the first time in American history, neither the president nor the vice president had been chosen by the American voters. Ford had become president because he was appointed by Nixon after Agnew's resignation. So Ford had never been elected vice president. And when Nixon resigned, Ford became president, again, never having been elected. And so the 25th Amendment was passed, and it has 4 sections. And the first 2 sections are not remarkable in any way. The first section says that in case of the removal of president from office or his death or resignation, the vice president shall become president. Well, that seems logical and unsurprising. The second section says that whenever there is a vacancy in the office of vice president, the president shall nominate a vice president who then shall be confirmed by both houses of Congress. Again, nothing remarkable. It's the 3rd and 4th section of the 25th Amendment that really deserve our attention. Under Section 3, the president may voluntarily turn over the reins of power when suffering a temporary disability. Now, this has never been invoked. The 25th Amendment has never been invoked, not even when President Reagan was shot in 1981, or when he was undergoing surgery in 1985. But for our purposes, it's Section 4 that garners our attention today. and I'm sorry for the blurred image, but this was the best I could come up with. So let me read it to you. Whenever the vice president and a majority of either the principal offices of the executive departments or of such other bodies as Congress may by law provide, transmit to the president pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the president is unable to discharge the powers and duties of his office, then the president shall be removed. So, Section 4 allows the vice president and a majority of the cabinet offices to declare that the president is disabled. And then the vice president would assume presidential duties until the disability ends. Now, Section 4 also allows the president to contest the decision to declare him disabled. And in that instance, Congress decides by a 2/3 vote whether the claim that the president is disabled is valid or not. So there's pressure on Vice President Pence, as we speak, to invoke the 25th Amendment if he can get a majority of Trump's cabinet members to go along. Now, today, the Secretary of Transportation, Secretary Chu, resigned. I believe she is Mitch McConnell's wife. Yes. So she resigned, which in a way is unfortunate because now she can't vote as a cabinet member to invoke the 25th Amendment. I think chances of the 25th Amendment being invoked at this point is extremely remote. First of all, you got to convince Pence to initiate the vote among cabinet members. And we're talking about cabinet members who are appointed by Trump and who may be very reluctant to vote to remove Trump from office. It's more likely that the House of Representatives will cast a vote to impeach Trump a second time. Now, personally, I think even though there's just 14 days left in Trump's presidency, I think for the viability of American democracy, it is absolutely essential that either the 25th Amendment is invoked or that he is impeached. What he did yesterday meets every definition of treason by inciting a mob to, and these were his words, go wild as he directed them towards the Capitol. And that is exactly what they did. They broke into the House and the Senate. There was violence. It met every definition of an insurrection. And given that Trump has expressed no remorse whatsoever, in fact, today he referred to those people as patriots, then the only remedy for a treasonous president is removal from office. And if he is not removed, there is nothing that he would not do to remain in office beyond the next 14 days. And that is why I think we are in very perilous times. So before leaving the 25th Amendment, I want to mention that when President Reagan was shot on March 30th, 1981, you may remember that a very nervous Secretary of State, Al Haig, declared that he was in charge. However, he was not. He was mistaken, believing that he was next in line of succession after the vice president, but the Speaker of the House and the President pro tempore were ahead of him. Okay, now let us turn to the first 10 amendments of the Constitution, also known as the Bill of Rights. In my last lecture series in December, we looked at the body of the Constitution, which basically details the powers of the federal government. In this series of lectures on the Bill of Rights, we will examine what the federal government is not allowed to do. When the framers met at the Constitutional Convention in 1787, they had to confront two major problems. How do you create a perfect balance between government power on the one hand and individual liberty on the other? That is, how do you create a government that grants power to the government while at the same time protects the liberties of individuals? And also, how can you protect the rights of minorities? And the solution, as we will see, was the Bill of Rights. In the Declaration of Independence, Thomas Jefferson referred to unalienable rights, the rights of life, liberty, and the pursuit of happiness. So when he talks about unalienable rights, he's referring to rights that are inherent in the human condition. Nobody bestowed these rights of life, liberty, and pursuit of happiness on us. These are unalienable rights. These are rights that we have from the moment we are born, not granted by the government. And because these rights are not granted by the government, they cannot be revoked by the government. But these rights, such as other rights, such as freedom of speech, press, assembly, these rights are not as simple as they may appear. The rights embodied in the First Amendment are not absolute, and the guarantees in the Bill of Rights are far from being clear and unambiguous. They've been the source of controversy and contention, particularly in recent years. For example, the debate over gun control is all about how you interpret the Second Amendment. And the specifics contained in the Bill of Rights are not very well understood by the general public at large. And so, for example, a poll taken in October of 2018 revealed that 20% of the people polled were not even familiar with what the Bill of Rights was. And half of those surveyed believed that liberty and the pursuit of happiness are rights protected by the First Amendment. They are not. They are inalienable rights. 37% could not list any right guaranteed under the First Amendment. So let us now go back in history and look at how the Bill of Rights came to be. It wasn't included in the original Constitution. Some people at the Constitutional Convention in Philadelphia thought it wasn't necessary to list the rights of individuals that government could not revoke, because each state had a constitution and each state constitution had a Bill of Rights. Now, the division of powers, as well as checks and balances in the Constitution, it was felt, would prevent any president or Congress from infringing on the rights of the people. So why do you need a Bill of Rights? They also argued that the Constitution already prohibited the suspension of habeas corpus and prohibited a religious test for federal office. Slave owners were afraid that a Bill of Rights might lead to an end to slavery. Nevertheless, powerful political leaders like Thomas Jefferson, George Mason, Samuel Adams, and Patrick Henry insisted that there must be a Bill of Rights attached to the Constitution, and they prevailed. They wanted specific protections to assure the rights of citizens against the power of this new federal government. The struggle for independence from Britain demonstrated to them that rights not written into documents were really insecure. When it became clear that states would not ratify the Constitution without a Bill of Rights, then James Madison saved the day on June 8th, 1789, when he promised the first Congress that the first Congress would enact a Bill of Rights. And because the states were now assured that there would be a Bill of Rights, on June 21st, the Constitution was approved when New Hampshire became the 9th state to ratify. States would not have ratified the Constitution without a promise that there would be a Bill of Rights. The first 10 amendments became part of the Constitution on December 15th, 1791. By then, as I said, every state constitution included a Bill of Rights, but this was a federal Bill of Rights intended to restrict the new government. It only required that the national government not violate these rights. And thus the First Amendment begins with the words, "Congress shall make no law." The concern wasn't for what state governments might do. In fact, the states' governments were sometimes considered the bastions of freedom against a possibly oppressive federal government. Therefore, the Bill of Rights in the Constitution applied to the national government, not to the states. And we will come back to that. The inspiration for the Bill of Rights came from English history and from the American colonial experience. The Eighth Amendment that prohibits excessive bail and prohibits cruel and unusual punishment. This incorporated language that the House of Lords in Britain used in the year 1316. The Third Amendment that prohibits quartering of troops came from our colonial experience, as did the Fourth Amendment that prohibits unwarranted searches and seizures to which the colonists were regularly subjected. Interestingly, the Bill of Rights aroused little enthusiasm after it was ratified in 1791. And it was not an issue in American politics, really, not until the 20th century. But in the 20th century, the Bill of Rights became quite controversial with the internment of Japanese Americans in World War II, with infringements on freedom of expression during the hysteria of the Red Scare of 1920 and the McCarthy Red Scare of the 1950s. And more recently, the issue of separation of church and state goes directly to rights incorporated into the Bill of Rights, as well as gun control and the rights of the accused. So we are now going to look at the nature of the First Amendment. The First Amendment includes rights that many consider are the 5 most important safeguards for the American people. The First Amendment says Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Now, later in this lecture, we are going to dissect exactly what that means. But a second right in the First Amendment says that Congress shall make no law abridging freedom of speech. The third safeguard in the First Amendment prohibits the government from abridging freedom of the press. The fourth safeguard is the right of people to peaceably assemble. And the fifth safeguard is the right to petition the government for a redress of grievances. And by the way, those demonstrators, I should say rioters, insurrectionists, yesterday were claiming that all they were doing was petitioning the government for a redress of their grievances. No, there are peaceful avenues to petition the government for a redress of the grievance, not the violence that happened yesterday. So these five freedoms, religion, speech, press, assembly, and petition, are sometimes collectively referred to as freedom of expression. Now, because the First Amendment protects the expression of deeply held convictions, it also exposes deep differences among the American people. And it has been the subject of challenges and court interpretations, particularly in the 20th and 21st century. So these are the five freedoms included in the First Amendment. Now, when it says Congress shall make no law, by specifically referring to Congress, the Bill of Rights limits only the government, not private parties. So, for example, the government cannot punish someone for their speech, but a private business could fire an employee for something that the employee said. Thus, freedom of speech in the Bill of Rights only refers to what Congress cannot do. Congress cannot pass a law abridging freedom of speech. But again, this only applies to the federal government, not to the states. It wasn't until the passage of the 14th Amendment in 1868 that the Federal Bill of Rights applied to all the states as well. And although the First Amendment says that Congress shall make no law regarding the freedom it contains, the Supreme Court has ruled that almost all rights have limitations. So none of the rights in the Bill of Rights are absolute. Let us begin with freedom of religion. One of the most remarkable aspects of the Constitution was its recognition of freedom of religion. Under the Declaration of Independence, which invokes the blessings of divine providence, unlike the Declaration of Independence, the Constitution makes no reference to a creator or to a God. The Declaration of Independence refers to the laws of nature and of nature's God, laws that are endowed by their creator and the protection of divine providence. But the Constitution makes no reference to God, to a creator, or to divine providence. The Constitution is a purely secular document, and it specifically bars any religious test for federal office holders. No religious test shall ever be required as a qualification or to any office or public trust under the United States. Now, when Alexander Hamilton was asked, why was there no mention of God in the Constitution? He replied, quote, "We saw no need for foreign intervention when writing the Constitution." Now, one nation under God in the Pledge of Allegiance, that was not added to the Pledge of Allegiance until 1956. And so it is not part of the Constitution. Let us look at the state of religious liberty in early America. The Puritan or Congregational Church became the official religion of the New England colonies. The Church of England, or the Anglican Church as it was called, was established throughout the southern colonies. And colonists were forced to go to church on Sundays. They could be whipped for failing to know church doctrines. In New England, Quakers were executed for their faith. After the American Revolution, Virginia became the first state to protect religious liberty. The Virginia Statute for Religious Freedom, invoked in 1786, was drafted by Thomas Jefferson, and it guaranteed that no Virginian could be denied the right to vote or hold public office because of his religious beliefs. It was one of Jefferson's proudest accomplishments. And as a matter of fact, he insisted that it be noted on his tombstone. So his tombstone reads, "Here was buried Thomas Jefferson, author of the Declaration of Independence, of the Statute of Virginia for Religious Freedom, and father of the University of Virginia." So what's missing from his tombstone? No mention that he was ever president of the United States. So he was more proud of his work on the Declaration of Independence and his establishment of freedom of religion in Virginia than he was about being president. Now, that same principle of religious freedom was included in Article 6 of the Constitution, which forbids any religious test for federal office. Now, the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So it really consists of two clauses: the Establishment Clause and the Free Exercise Clause. And these two clauses sometimes conflict with each other. It's difficult for the government to avoid an establishment of religion on the one hand, while at the same time protecting its free exercise. If a student raises his or her hand and says, "Teacher, can we say an opening prayer before taking this test?" If the teacher says yes, it looks like that's establishment of religion. If the teacher says no, then it seems that the teacher is denying a student's free exercise of religion. So do you see how these two clauses can sometimes be in conflict with each other? Now, when it comes to religion, there are people who fall on the side of accommodationists and others who fall on the side of separationists. In answer to the question, yes, there's a wall between church and state, but how high should that wall be? Accommodationists contend that the state should not be separated from religion, but rather that government should accommodate religion without showing any preference for any specific religion. Separationists, on the other hand, argue that the wall should be high enough to completely separate church and state. So, whereas accommodationists believe that the government could and should make allowances for the significant role that a religion has played in American life, such as allowing the display of the Ten Commandments on public property, separationists argue that the Constitution absolutely prohibits any mingling of religion and government. Now, it should be noted that the phrase separation of church and state does not appear anywhere in the Constitution. It does not appear anywhere in the Bill of Rights. However, Neither does the Constitution refer to God, a creator, or divine providence. Now, separation of church and state is generally traced back to 1802 in a letter that Thomas Jefferson sent to a Baptist associate in Danbury, Connecticut. Is there a wall of separation between church and state, or is it more like a fence? Although the First Amendment specifically prohibited the establishment of religion, that did not apply to the states. After the adoption of the Constitution, some states continued to prevent Jews, Catholics, and atheists from occupying public offices, and that was well into the 19th century. Maryland required a declaration of belief in God for anyone who wanted to hold office in the state of Maryland up until 1961. Several states still have language included in their constitutions that require state office holders to have particular religious beliefs, although these provisions have been rendered unenforceable by Supreme Court decisions. So let us look at what the Establishment Clause allows the government to do and what it prohibits the government from doing. So, under the Establishment Clause, you can teach about religion in schools, but you cannot advocate for any particular religion. You can allow voluntary prayer in many examples. So, for example, if students want to leave the classroom and pray in a religious club on school grounds, that is permissible. You can transport students to religious schools using public school funds. And it is permissible to read the Bible for cultural or literary content, not for the purpose of proselytizing a religion. What the Establishment Clause prohibits is you cannot set a state religion. Government cannot order people to pray. You are not allowed to teach religious doctrine in public schools. The government cannot pay seminary teachers with public funds. You cannot teach creationism without teaching Darwinism as well. And by far, most establishment cases are about religion in the schools. So let's take a look at 6 specific Supreme Court cases about religion in schools. First, the issue of school prayer. In a case in 1962, Engel versus Vitale, a New York State Board of Regents approved a prayer for recital each morning in New York public schools. Engel was a parent in the district, and he argued that the regent's prayer violated the Establishment Clause of the First Amendment. And also remember, the 14th Amendment applies the Bill of Rights to the states. So Engel was claiming that mandating a school prayer was tantamount to establishing a religion. The Supreme Court ruled that state-sponsored prayer in public schools was an unconstitutional violation of the Establishment Clause that, quote, breaks the constitutional wall of separation between church and state. In another case in 1992, Lee versus Weissman, the Supreme Court ruled that official prayers at graduation ceremonies in public schools were also unconstitutional. But the Supreme Court never outlawed voluntary prayers by individual students. Another issue surrounding religion in schools has to do with aid to parochial schools. In a case, Lemon versus Kurtzman, 1971, the Supreme Court ruled that aid to church-related schools must meet the following three parts of what they call the Lemon test. The aid must have a secular purpose. The primary effect of the aid should not be either to advance or inhibit any particular religion. And the aid must not excessively entangle government with religion. And so the federal government can subsidize the cost of textbooks in religious schools. Another issue surrounding religion in schools have to do with public vouchers that allow parents to pay tuition to religious schools using public funds. In Zellman versus Simmons-Harris in 2002, the Supreme Court ruled that a voucher system did not violate the Establishment Clause. It held that a voucher system is constitutional, quote, if it is neutral with respect to religion and provides assistance to a broad class of citizens. Now, dissenting judges argued that using tax dollars to pay for religious indoctrination can never be considered neutral regarding religion. A third issue surrounding religion in the schools has to do with the teaching of evolution. In 1981, Louisiana enacted a law mandating the teaching of biblical creation along with the theory of evolution. In Edwards versus Aguillard, 1987, the Supreme Court ruled that the Louisiana law violated the Establishment Clause because the law had no secular purpose. Another issue surrounding religion in the schools has to do with equal access. The courts have consistently ruled that public schools receiving federal funds must allow student religious groups to meet if the school allows other non-curricular clubs in general. So student religious groups can meet after the school day or meet outside the classroom as long as other non-curricular clubs are allowed at the school. And another issue surrounding religion in the schools has to do with religion in the public square. The Supreme Court has ruled that prayers to open legislative sessions are constitutional as long as they do not denigrate non-believers or religious minorities. And so the court has upheld religious displays at Christmas and Hanukkah as long as they include secular symbols of the season as well. So all of these issues pertain to the first clause, the Establishment Clause, that Congress shall pass no law establishing a religion. The second part of the clause is the Free Exercise Clause. Now, the First Amendment's Free Exercise Clause guarantees each person the right to believe whatever they want to believe. Religion cannot make an act illegal. Religion cannot make an act legal that would otherwise be illegal. Government can act when religious practices violate criminal laws, when religious practices offend public morals or threaten community safety. So, for example, in Oregon versus Smith, 1990, the Supreme Court banned the use of illegal drugs in religious ceremonies. Now, under the Free Exercise Clause, you can choose whatever religion you want to. You can ask questions about religion, and you can worship whomever you want to. But under the Free Exercise Clause, individuals cannot break the law and claim it is part of their religious belief. You cannot raise children and deprive them of education under religious beliefs. And you cannot deprive children of basic needs. For example, if a child is in need of urgent medical care, Christian scientists cannot deny children if their lives are in danger and would die without this medical care. There are limits on the free exercise clause. In Reynolds versus the United States, going back to 1879, the issue of polygamy came up when Mormons claimed that their religion made it a duty to marry many women. Now, the Supreme Court made an important distinction between religious beliefs on the one hand and religious practices on the other. And so the court can't restrict what a person believes because that lies solely between man and his or her God. However, the court said society has a right to legislate against religious activities that violate the law of the land. And so, in this case, Reynolds versus the United States, the court upheld the federal law that prohibited polygamy, even though Reynolds, a Mormon from Utah, claimed it limited his religious freedom. The Supreme Court argued that permitting polygamy would, quote, make the professed doctrines of religious belief superior to the law of the land. And in effect, it would permit every citizen to become a law unto himself. Another very controversial issue surrounding this same clause, the free exercise clause, has to do with saluting the flag. In Minersville versus Gobetis in 1940, the Supreme Court ruled that a Pennsylvania school had the right to insist that Jehovah's Witnesses say the Pledge of Allegiance or suffer punishment. Now, Jehovah's Witnesses do not pledge allegiance to any symbol other than God. And so students who were Jehovah's Witnesses refused to stand and pledge allegiance. But the Supreme Court ruled that the importance of national unity overrode their religious beliefs. Now, this is 1940, when Nazi Germany was becoming a real threat. World War II was already underway, although the United States had not yet entered. But because the Supreme Court ruled against Jehovah's Witnesses in Minersville versus Gobetis, it became open season against Jehovah's Witnesses throughout the United States. Members were attacked by vigilante groups who were supported by law enforcement. And so 3 years later, the Supreme Court reversed its decision in West Virginia versus Barnett. In a 6-3 vote, the court ruled that when the majority argued that state law compelling the pledge, that state law violated the First Amendment. And so students can no longer be forced to pledge allegiance to the United States, at least to make the pledge in classroom. Another part of the First Amendment is freedom of speech. The framers believed that the right to free speech was a fundamental natural right. And the First Amendment states, Congress shall make no law abridging the freedom of speech or of the press. Both the First and 14th Amendments protect free speech from incursion by both federal and state governments. Freedom of speech, as protected by the First Amendment, means defending speech we hate, not just speech we love. And as we can see this quote from Noam Chomsky, if we don't believe in freedom of expression for people we despise, then we don't believe in it at all. Even if a doctrine is wrong, it does not follow that it should be silenced. And so freedom of speech means permitting the expression of offensive, odious, and sometimes hurtful ideas. And so the First Amendment protects speech such as Holocaust denial, as odious as that is. It protects racial denigration. It protects hate speech. English philosopher John Stuart Mill argued that wrong or offensive ideas actually force us to sharpen our views. If we believe in free expression, we must believe in its power to overcome error in a fair debate. Well, before we get into cases involving freedom of speech, it's important to define exactly what we mean by speech. And so, for example, is political demonstration a form of speech? Is picketing a form of speech? Is wearing political symbols a form of speech? Even donations to political candidates have been interpreted as a form of expression. Now, when the First Amendment says Congress shall pass no law, does it really mean no law? Is this an absolute expression? Not exactly. We must keep in mind that the rights and liberties contained in the Bill of Rights are not absolute. Each right has its limits. Each right carries along with it responsibilities. There's an expression that says, your right to swing your arm ends at the tip of my nose. And so every right has limitations because it's important to balance between freedom of expression with the need to maintain public order and national security. So, for example, you are not free to incite violence against the American government. You cannot say, well, I'm just exercising my freedom of speech. No, because inciting violence against government endangers national security. And there's no doubt in my mind that that is exactly what Trump did yesterday by inciting the rabble to descend upon the Capitol and go wild. So, what is allowed under freedom of speech? What can the individual do? Well, you can express any political belief. And so, some years ago, the American Nazi Party wanted to march down the streets of Skokie, Illinois, where many Holocaust survivors lived. That is protected speech, odious as it is. Free speech means that you can protest peacefully, that you can say things about someone that are not true, that you can say anything that's not true. Our president has exercised that tens of thousands of times. And freedom of speech protects your right to say racist things and hate slogans. But there are limits on freedom of speech. And so you cannot say things that are false that injures a person's reputation. That is slander. You cannot threaten to blow up airplanes or schools or to kill the president. Freedom of speech does not allow you to harass someone sexually. You cannot create excessive social chaos through your speech. You cannot use extremely crude language in a public forum. You cannot use disrespectful, vulgar language in school. And you cannot commit hate crimes and claim that you're protected by free speech. The most famous free speech case was what was called the clear and present danger test. It was in 1919 in what was called Schenck versus the United States. Now think about this. Between 1791, when the government first began, and 1919, there were no speech cases that came before the Supreme Court. During World War I, Congress passed the Espionage Act that prohibited forms of dissent deemed to be harmful to the nation's war effort in World War I. Charles Schenck, who was the General Secretary of the Socialist Party, was opposed to American participation in World War I. And so he mailed out 15,000 leaflets urging young men to oppose the draft. And government responded by convicting Schenck for violating the 1917 Espionage Act. And the Supreme Court upheld his conviction, ruling that speech creates a clear and present danger. And as clear and present a danger as if someone were to shout fire in a crowded theater. If someone yelled fire in a crowded theater and there was no fire, and there was a stampede, and some people were trampled to death, that person could not say, well, I was just exercising my freedom of speech. So the court ruled that freedom of speech is limited if it creates a clear and present danger. So that is the restriction of freedom of speech. Now, in a subsequent case, just a few years later, Abrams versus the United States, Justice Oliver Wendell Holmes dissented when he said, the best test of truth is the power of the thought to get itself accepted in the competition of the market. In other words, the best weapon against false or inflammatory speech is more speech. So Oliver Wendell Holmes is saying that we should allow any speech, no matter how disgusting, because we could then refute those ideas in the free marketplace of ideas. So the clear and present danger test created a precedent that the First Amendment guarantee of free speech is not absolute. And so in 1940, the Smith Act forbade anyone to advocate the violent overthrow of the American government. But by the 1960s, the political climate had changed. And so in Brandenburg versus Ohio, the court ruled that speech that incites illegal action can only be punished if such action is imminent and probable. So, for example, if a member of the Ku Klux Klan calls for the violent opposition to civil rights laws, that is protected speech. But a specific call to bomb churches at a specific time and place, that is not protected speech. So the court is saying we have to look at the impact of that speech to see whether it is protected or not. Now, a type of speech not protected by the First Amendment is referred to as fighting words. Abusive and insulting comments delivered face to face that have a direct tendency to cause acts of violence is not protected. On the other hand, the Supreme Court has ruled that hate speech is protected by the First Amendment. So For example, if a racist were to stand up in the middle of Harlem and say viciously racist and vile things against Blacks, and that resulted in some violence, then that is not considered protected speech. University codes outlawing hate speech have frequently been overturned as violations of the First Amendment. So the First Amendment does protect hate speech unless it leads directly to some form of violence. Now, there's also something called symbolic speech. In Tinker versus Des Moines, 1969, the Supreme Court upheld the right of students to wear black armbands to school to protest the Vietnam War. Justice Abe Fortas stated that students and teachers do not shed their constitutional right to freedom of speech or expression at the schoolhouse gate. So in this case, Tinker versus Des Moines, these students wore black armbands to protest the Vietnam War. They were expelled from school, and the case went up to the Supreme Court, and the Supreme Court ruled that the school district was wrong, that wearing armbands protesting the Vietnam War was considered protected speech. But in U.S. versus O'Brien in 1968, the court ruled that burning a draft card was not protected by the First Amendment. In that case, it held that the government had a valid purpose in punishing the burners of draft cards, which was necessary to raise and support an army. On the other hand, in Texas versus Johnson, 1989, the Supreme Court ruled that burning of the American flag was protected by the First Amendment. In that case, the court ruled that the government may not prohibit the expression of an idea simply because society finds that idea offensive or disagreeable. So in the 1968 case, it ruled that draft card burning was a criminal offense because it was part of a process to defend national security. But burning of the American flag did not threaten American security, and therefore that was protected by the First Amendment. The court also noted that burning is the proper way to dispose of a tattered flag. But the Supreme Court has ruled that the First Amendment does not protect symbolic speech that is intended to incite illegal actions. So, for example, states may make it a crime to burn a cross with the intent to threaten racial violence. Okay, well, we are about at an end to our hour, and so next week we'll continue with rights in the First Amendment, beginning with freedom of speech. But at this